Hello students, welcome to 1 PYQ, a day series of law optional. Here we pick up one question from the previous year and try to understand what is asked in the question, try to understand the central point of the question. So today's question is taken from year 2025 and it's a 10-marker question. Now this question is pretty much asking about the criticism of one of the judgments given by the Supreme Court. Okay, so let's read what is asked in the question. It is often said that the decision of the Supreme Court in L. Chandra Kumar versus Union of India, now this case is of 1997, has defeated the very raison d'etre of establishing administrative tribunals in India. Now before we delve into the question, let us understand what is the meaning of this word, raison d'etre. It simply means the most important reason. So what was the most important reason of establishing of the administrative tribunals? Now, as you know, and let me tell you, administrative tribunals were established by the 42nd Constitutional Amendment Act in 1976. It has introduced a new part number 14A, whose name was tribunals in the Indian Constitution. Along with it, it also has given two important articles, Article 323A and Article 323B. This one for the administrative matters and this one for the other matters which may contain the taxation matters and any other kind of matters. Okay, so this was a new kind of administration which was started by the 42nd Constitutional Amendment Act, and the decisions of these tribunals were final. The decision was final. The finality of the decision was there. That simply means the High Courts and the Supreme Court was excluded, was not allowed to take any kind of review or any kind of appeal coming from the judgment made by the tribunals under Article 323A and 323B. This has considerably reduced the kind of burden which high courts used to have. All these service matters and the administrative matters and the other kind of matters used to go to the high courts. Now the burden has been considerably reduced because of introduction of this particular part and these two articles. Because of that, tribunals were made, and the arrears or the burden of the high court was considerably reduced. But then what happened in 1997, L. Chandra Kumar versus Union of India? Under this case, the Supreme Court, and by the way, let me tell you, high courts, they were excluded. Supreme Court was also excluded, but not under Article 136 special leave petition. Under Article 136, special leave is the discretion of the Supreme Court and can be given in any case. So if it has to take some matter under Article 136 as a special leave petition, it has the power to do so. Similarly, all the matters coming under the, the dispute related with the river water, Article 262, if you remember, those matters are also taken up by the Supreme Court under Article 136 special leave petition. Now coming back to our administrative tribunal, what has happened in this particular case of L. Chandra Kumar versus Union of India? The Supreme Court said that appeal from the judgment given by these tribunals will be allowed, and the High Court can take up such appeals. That simply means the finality of the decision was no more there. The tribunals did not show the finality of the decision, but rather has become the court of first refuse. That means if anything happens related with the administrative matter or any other kind of matter, the first thing which you have to do is to go and approach the tribunals, and then you can go to the High Court. So instead of reducing the burden of the High Court, the burden of the High Court have considerably been increased, because there is more and more, every day there are more and more matters related with services, related with administration and other matters. So this is what the question is asking. The very purpose of establishment of administrative tribunals in India by the 42nd Amendment Act have been, reduced to and, flattened by this particular judgment of the Supreme Court. So basically, many legal experts and administrators criticize this. Supreme Court said that the power of judicial review is the basic structure of the Indian Constitution, and that is the reason why the appeal to the judgment made in the tribunals will be allowed to go to the High Court, hence increasing its burden even more. So this is what is asked in the question. So thank you very much for joining me. I am going to come up again with the next question. Have a nice day. Jai Hind.